Good afternoon, everyone, and thank you all for joining us for this criminal record expunction listen and learn. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. If you are unfamiliar with the format of this event, first we're going to watch an informational video on this area of the law. At the end of the video, we will have a question and answer session with one of our second chance attorneys. You can put your questions in the Q&A box on Zoom or in the comments section on Facebook at any time. We'll review all questions put in the chat boxes during that Q&A session. Please remember that this is a public forum and legal aid is not representing you. So please remember not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'll go ahead and start the video. This presentation was created by Legal Aid of North Carolina. This presentation only provides legal information and not legal advice. The information presented is based on North Carolina law only.
What is an expunction? Expunction means to permanently remove an offense or a conviction from a criminal record. When an expunction is granted by the court, the public criminal record of the expunged offense or conviction is destroyed. Once somebody receives an expunction, they can truthfully deny that the expunged offense or conviction ever occurred. There are three primary types of expunction. There are the expunction of not guilty charges, the expunction of dismissed charges, as well as the expunction of convictions. We will review the three types of expunction. We'll start with the most common types of expunction, and then we'll get into the expunction of convictions. So the first type is the expunction of not guilty charges. Now, these are all charges where someone was found not guilty of the offense that they were charged with. These types of charges are eligible to be expunged. Next is dismissed charges, and these are all charges that were dismissed. These are also eligible to be expunged. Now, most charges that are dismissed after December 1st, 2021 will be automatically expunged 6 months after they are dismissed. However, if somebody has dismissed charges prior to December 1st, 2021, they will need to file a petition to seek the expunction of those dismissed charges, and those types of dismissals will not be automatically expunged. All of that to say, if somebody has dismissed charges that were disposed of prior to December 1st, 2021, they are still eligible to be expunged. That person would just need to file the petition and file it with the court to seek that expunction, as opposed to most charges that are dismissed after that December 1st, 2021 date. Those will be automatically expunged from that person's record 6 months after the disposition. Now, let's talk about the expunction of convictions, and these are where somebody was found guilty or pled guilty to an offense that they were charged with. There are two categories of this type of expunction. There are what we call youthful convictions as well as adult convictions. Youthful convictions are also known as raise the age convictions. Now, these are most misdemeanors and some Class HRI felony convictions that were committed before December 1st, 2019, when the person was 16 or 17 years old at the time of the offense. These types of convictions are eligible to be expunged. Adult convictions. These are some misdemeanors and few felony convictions when someone was 18 years old or older at the time of that offense may be eligible for expunction. Now, there are a number of what we call disqualifying convictions that could prevent somebody from expunging any of their adult convictions. Now, the law that speaks to the expunction of adult convictions includes a list of offenses that are not eligible for expunction, and the statute that speaks to that is listed on the screen. Now, if somebody has a conviction for any of these types of offenses, that person is not eligible to expunge any convictions that occurred when that person was 18 years old or older. However, that person may still be able to expunge any race to age or youthful convictions that they may have, and they are also still eligible to expunge any dismissed or not guilty charges that they may have. Some of the most common ineligible offenses include Class A through G felonies, such as common law robbery or the sale of drugs. We have Class A1 misdemeanors. The most common ones that we see are misdemeanor child abuse. Domestic violence protective order violations are also Class A1 misdemeanors. We have any convictions that require sex offender registration. We have assault offenses, so any offense where assault is an essential element of that offense. So, as on the screen, assault on a female, simple assault. If assault is in the name of the charge, it's likely going to be disqualifying. We have any offense that involves heroin or crystal meth. And then we also have possession with intent to sell or deliver cocaine, which we abbreviate to be PWISD cocaine. And this differs slightly from any felony offense involving heroin or crystal meth, because mere possession of those types of drugs is disqualifying, as opposed to cocaine, where felony possession of cocaine is not. There needs to be some further intent with cocaine in order for that to be disqualifying. And again, these are just the most common. There are a couple more on that list, but all of that to say, if somebody has a conviction for one of these types of offenses, what that means is that they are not eligible to expunge any adult conviction that they have on their record. Now, I'm going to walk through what the general expunction process looks like. This can vary in time, meaning it really depends on a multitude of factors how long this process can take. But generally, no matter what type of expunction someone is seeking, the process will look generally the same. And so the first step is obtaining an accurate and complete copy of the criminal record. In order to be able to move on to step 2, which is determining eligibility for expunction, somebody needs to make sure they are reviewing an accurate and complete copy of the criminal record that they are seeking to expunge. And so once somebody has that complete record, they can move on to step 2 and determine, based on what is on that record as it applies to the law, what may or may not be eligible for expunction. Now, step 3, if it is determined that someone does not have any offenses that are eligible for expunction, the process stops at this point. There are no further steps to be taken. However, if it is determined that somebody does have offenses that may be eligible for expunction, we continue on to the next step, which is to identify the correct petition form for that type of expunction. There are separate petition forms for each type of expunction, and these are standard forms from the administrative office of the courts. And so depending on the type of expunction relief somebody is seeking, there is a specific form that that individual would need to complete in order to get that process started. Now, once somebody has identified the correct petition form based on the relief they are seeking, they would want to complete it and any required documentation that may be needed depending on the type of relief they are seeking. That to say, when it comes to expunging convictions, there are supporting documents that are needed in order to support the expunction. And so that individual would need to not only complete the petition form, but also want to complete those documents and file those with the court at the same time. Once all of the petitions have been drafted and all of the supporting documents have been completed, the next step is to identify and follow any county-specific procedures for filing. And what that means is there are 100 different counties in North Carolina. And so there are 100 different ways that somebody could go about filing the petitions in the counties that they need to file in. And so depending on the counties that somebody is working in, they would want to reach out to that clerk's office to inquire about how best to get their paperwork filed as needed. Now, to this point, petitions for expunction need to be filed in the county and division where the expungable offense occurred. And what this means is, for example, if somebody has dismissed charges that are eligible in Wake County and Johnston County, that person would be completing at least 2 different petition forms, one for the dismissals in Wake County and one for the dismissals in Johnston County. Now let's say in Johnston County that person had dismissals in Superior Court as well as District Court. That person would be filling out 2 different dismissal petitions, one for Johnston County District Court and one for Johnston County Superior Court. And so when we say they need to be filed in the county and division where they occurred, that is an example of what that may look like. And so if somebody has a record that spans different counties and different court divisions, depending on the relief they are seeking, there could be a number of different petitions that need to be filed. Now, once somebody has filed all of the expunction petitions that they have worked on and are waiting to hear back from the court, again, how long that takes can vary county to county. But ultimately, by the end, that individual should receive the expunction petition that they filed, either denied by the court or hopefully granted by the court. And if the petition is granted, that means the expunction was granted by the judge. And so if somebody receives a granted order from the court, what they would want to do at that point is to verify that that expunction was certified. And what does that mean? There are public terminals in each courthouse where somebody can input their information to confirm that the expunged offenses no longer show up in that database. And that is the ultimate goal, because if somebody were to type in the file number of the expunged offense, it should no longer show, meaning that the clerk, upon the granting of that expunction from the judge, has gone into their system and deleted reference of that expunged offense from the public database. Now, to that point, again, to reference back to the beginning of this presentation, expunction means to remove the public criminal record of an offense or conviction. And so to that end, there are still certain agencies that are still able to access expunged records. However, as I will get into in the next slide, they can only access them for very specific purposes. So access to expunged records. These expunged records can still be accessed by prosecutors. So these are district attorneys. They can still see and use expunged records for sentence calculations. So meaning if somebody were to be charged with another offense and they are subsequently found guilty or plead guilty to that offense, district attorneys can look at expunged records that that person may have had in the past and can use those when it comes to determining the person's sentence for that new offense that they were found guilty of or pled guilty to. Additionally, they can also use it for what we call habitual offender status. So again, it's kind of the same concept. If somebody is charged with another offense, plead guilty, found guilty, district attorneys can use the expunged offense to determine if somebody should be classified as a habitual offender. The next entity that can see them are arresting agencies, and that is because they keep what are known as investigative records, and the database that they use is not available to the public. And so if somebody doesn't work in an arresting agency, they're not able to see or access those records. And so they are not required by law to delete expunged offenses from their investigative records. And one of the main reasons is because it's not publicly available. And last, we have law enforcement agencies, and they can see expunged offenses and records for employment purposes. So if somebody is seeking to become employed at a law enforcement agency, that agency can see expunged records if that is the case, if that person has any of those. And then additionally, for certification purposes. And so if somebody is looking to obtain some kind of certification within the law enforcement agency, they can also see expunged records for those purposes as well, in determining whether, somebody should be hired or if somebody should receive that type of certification.
This presentation was brought to you by Legal Aid of North Carolina. Legal Aid of North Carolina is a statewide nonprofit law firm that provides free legal services in civil matters to low income people in order to ensure equal access to justice and remove legal barriers to economic opportunity. Legal Aid of North Carolina offers listen and learns on several topics, including criminal record expungement, child custody, Medicaid rights and eligibility, simple divorce, Social Security disability, SNAP benefits, tenant rights, and wills and powers of attorneys. Now that the video has ended, we will open it up for the Q&A session. Today we have attorney Trenner Bender with our Second Chance project. Please remember that while Trenner is an attorney, she is not your attorney. She cannot respond to specific legal questions. And then before we get into questions, Trenner, I think you wanted to say something about potential people applying for assistance from legal aid.
Sure. Thank you very much, Marissa. Hello, everyone. Like Marissa just said, I just wanted to say that my name is Trenner Bender. I'm a staff attorney here with Legal Aid of North Carolina in our Second Chance Department. We handle criminal record expunction and a limited amount of driver's license restoration. Since we cannot answer specific questions in this forum because we are not your attorney and we don't have all the specific knowledge of your case, if you are interested in opening up a file with us, we are going to be opening intake for our Second Chance project coming up. So coming up, our intake will be open during the first full week of each month online at our Justice Hub. I believe Marissa could probably put that in the chat, the link to that. Just to clarify, the weeks we will be open so far are February 2nd through the 6th, March 2nd through the 6th, April 6th through the 10th, May 4th through the 8th, and June 1st through the 5th. That we can open up expunction files for anyone, anywhere. However, do be advised that due to a limited amount of funding restrictions, we can only open driver's license restoration files for if you are a resident of either New Hanover County or Durham County. So again, you can go online to our Justice Hub and complete an application there, and then we will be getting back to you. And at this point, I'll open it up to questions.
Perfect. And I did put a link, as Trina mentioned, to our Justice Hub in the chat on both Zoom and Facebook. Okay, you just talked about, for those of you with your hand raised, you cannot unmute in this forum. So if you have a question, you need to type it into the Q&A box. First question is kind of clarifying about how long does it take for an expunged charge to no longer show up?
Okay, so that depends. Really depends on what the charge is, what kind of charge it is, and where it is. Once a charge has been expunged from your record, it should be removed from the North Carolina Criminal Record Database portal almost immediately. However, if the charge is severe enough where you had a Department of Adult Corrections record or were fingerprinted for the charge, and you have a State Bureau of Investigation record, an SBI record, that can take a little longer. That can take a little more like 6 months before it will come off of that SBI record. Additionally, don't forget that there are some entities who will still be able to see those records. Not all of them, but certain entities will still be able to see records of the charges even after that time, as Lorena mentioned in the video.
Perfect. Someone's asking if someone doesn't qualify to have the filing fees waived, would they need to pay the filing fee for each petition they file? Like, say they have to file in multiple counties and multiple divisions, do they have to pay a filing fee for each one of those petitions?
Gotcha. No, that's a great question. And so the answer is if you were a client of ours for Legal Services of North Carolina, you automatically will qualify to have the filing fees waived for expunction petitions. If you do not qualify to have the filing fees waived for your expunction petitions, you would, yes, have to pay that fee for each petition that you file. Now, do remember there is no filing fee to file for dismissed charges, only for convictions that occurred before you were 18 or for adult convictions.
I'm assuming this one is, I'm not sure what rights are impacted, but say a felony got expunged, this person is asking will their rights automatically be restored. I don't know if you can understand that enough to respond to that.
I can. And so it depends on exactly what the charge is and where it occurred. In the state of North Carolina, generally your rights are upon your expunction, your rights will be automatically restored. But I cannot speak on what impact that expunction would have on your rights in other states. I can only speak on North Carolina.
Perfect. For those asking about being able to review the presentation, I will discuss that at the end of the Q&A. Um, so another clarifying question, if an offense is expunged, will it still show up on a background check?
Again, that depends on what type of background check it is. Once it has been removed from the State Bureau of Investigation records and the North Carolina database, it should not appear on a regular background check. Now, there are some situations where if you go use like a third party, you'll go online and it'll be one of those like private background check. I can't, there's a bunch of them. Occasionally, those entities will use outdated records, and which means that they would have pulled the record before the expunction took place and then their record is outdated. That's what's called a ghost record, and occasionally a charge will show up that way. If that does happen, you there is a form you can fill out to ask that private background check company to remove that record from their system. Again, though, um, with certain types of government jobs, there those entities are allowed to see your full record, including an expunged record. Those are generally jobs that are in law enforcement or that type of position where they can in fact see your entire background check, including the expunged charges. But that's not most background checks. So the answer to that is no. Again, I will point out that an expunction does not remove past offenses from your driving record.
Where did someone find the forms?
The form to, that's a great question. And I believe that form is on the AOC website. Let me see if I can find that real quick for you. Um, you can go on if you want to with the questions, and I can come back to that in a second.
Okay. I will go ahead and post a link to just the forms in general, that general website to the forms on the North Carolina court's website.
Thank you very much.
I have that. Yeah, here it is. Give me just a second, because I can't type and talk at the same time. Forms, so many fancy words. Okay. Next question. Are there types of convictions that once you get that expunged, you are not eligible for any more expunctions of your convictions or that kind of process?
Yes. When one gets when you get your adult convictions removed, like if you pursue an expunction of your adult convictions, then once you have done that, you have a period of 120 days to submit all the expunction petitions that you are going to submit. You're going to submit to expunge adult convictions. Once that time period has passed, you can under the statute you cannot pursue any other expunctions of adult convictions. There is a caveat in there for good cause, why, like maybe you didn't know that you had that conviction when you did your expunction petitions or something like that, but it certainly would not be any subsequent convictions. Any convictions you receive after the expunction process would certainly not be eligible. And most of the time, if you didn't get it in that first go round, then convictions would not be eligible if they were adult convictions. And I want to answer, I had asked a colleague of mine about it looks like what we have it for the convictions that show up on private background checks that have already been expunged. We have a letter that we send with our expunction petitions when we close our files. But I think basically what you would do is you would just contact the company that supplied you the background check that still is reporting the expunged charge. Supply them a copy of the expunction petition and ask them to remove the charge. Additionally, my colleague was telling me that if you go to the Consumer Financial Protection Bureau website, they have more information about how to protect your rights in that way. Excuse me. So that is the Consumer Financial Protection Bureau. Let me see.
Okay. I will try to find a link to that and post that in the chat as well.
Marissa, I can
Okay.
send it to you if you'd like.
Okay. Oh, well, I just found it. Maybe. Yes. Okay, I found it. Is it better to file an expunction with an attorney, or is it something someone can do on their by themselves reasonably?
I really think that the answer to that is depends on how complicated your record is. Um, because of the rule that I mentioned just a minute ago, requiring you to file all of your conviction petitions within the same 120-day window, if you know that you have multiple convictions across multiple counties, I would highly recommend consulting with an attorney to make sure that those petitions are filed in a timely manner and that you really get everything. As Lorena said in the video, one of the most important steps in the expunction process is to make sure that you have a complete and accurate criminal record to get started. That way you know that you're getting everything all at one time. And that is something that an attorney can really help you with if you know that your record is complicated. Now, that being said, if you have one particular conviction and you know that's all you have, I think that is definitely something that you could probably pursue on your own. You just want to make sure that you are using the right forms and submitting those forms to the right venues, as Lorena again mentioned in the video, the right courts where the conviction took place.
Okay. Um, got a couple asking, how much is the filing fee?
The filing fee is $150, I believe it is, for an adult conviction, and I think it is $50 for an underage conviction. And then, of course, the dismissal petitions, like I mentioned earlier, there's no filing fee for dismissals.
Couple questions asking, will the intake be open this month? And if so, what are those dates again? Or is it just in
Not in
February?
January. It'll be. Oh, you know what? Actually, I believe it is open right now, and so it's open. Let's see, from now until or yesterday until I believe. Let me see here. Just look at my calendar, so I don't tell you the wrong date. Until the 9th. And then the next open intake would be February 2nd through February 6th.
Got
And
you.
let me just correct myself here. The filing fee for the convictions is up to $175 now, I believe, per conviction petition, and then the underage convictions are 50.
Awesome. And then just to confirm, for those who are looking to apply with legal aid, we are asking that they apply online through the Justice Hub, correct? Not call is the
That's
preference?
correct. That's correct. We are
Yes.
taking those applications through the Justice Hub exclusively, only through there.
And for those of you asking if legal aid would be able to help, you have to qualify for services for legal aid, so you will have to complete an application. We cannot tell you whether or not you qualify. You have to go through the screening and complete an application to see if you are eligible for legal aid services. And to be eligible, you have to be both income and asset eligible. When you go on Justice Hub, there's a video that will explain those terms for you. But we in this form cannot tell you specifically whether or not you qualify for legal aid for those asking. Okay. I lost my questions. That one was answered. Someone saying if they only have a charge, I guess a charge or conviction in one county, they would only need to fill out the paperwork for that one county. They wouldn't need to fill out for every county in North Carolina, correct?
Yes, that is correct. But you do want to make sure, if you have them in district court and superior court, both in that same county, that you separate those two courts.
Okay. Um, Again, we can't respond to some of the more specific questions here. Da, da, da. Someone's asking what can they check to make sure something got expunged?
You
Is there
would
a way to
want to go
check that?
back. You would want to go back and check the same. Mostly we use the portal, which is the North Carolina Criminal Record Database, to compile a criminal record in North Carolina, and that's where you would want to check back to see if the charge had been removed.
Is there a certain amount of time someone has to wait after their conviction before they can be eligible for an expunction?
Yes, there is, and that is also a fairly complicated question. It depends on how many convictions you have and what types of convictions they are. If they are eligible, a single misdemeanor conviction is 3 years from the date of disposition or from when any active sentence is served, whichever it happened first, or whichever happened later, excuse me. For multiple misdemeanor convictions, it is 7 years from the end of the sentence on the latest conviction, so the end of the latest sentence. And then for felonies, it is 10 years from the end of your sentence for one, and if you were eligible for 2 to 3 felonies, that would be a 20-year waiting period from the end of your sentence. But again, the time I always hesitate to say time periods in general because there's a lot of interplay, meaning, depending on your entire criminal record again, can have an effect on whether or not those charges are eligible and also what the waiting period is and when that waiting period started. But there is a waiting period for all convictions, adult convictions.
Perfect. Um, for those asking about specific, whether or not specific offenses can be expunged, I have posted a link to Statute 15A 145.5 that was mentioned in the video, which has a link, which is all the information on some ineligible offenses that Trina can probably say that a lot better than what I just said about what
Yes,
that
there are a
statute means.
number of, like Lorena was talking about earlier, there are a number of offenses that are what we call disqualifying offenses. And those offenses will prevent you from being able to expunge that offense and then also any other adult conviction.
Perfect. Um, Someone's asking, say they live in a different state now, but their conviction was back in North Carolina. Would they have to come to North Carolina to get that expunged?
Um, Usually probably not. If you have representation in North Carolina, you should not have to come back to North Carolina to get it expunged. Your lawyer could usually appear on your behalf. Very occasionally, a court will require a petitioner to be actually present if there is a hearing. If you do apply for an expunction on your own, for convictions, there are many times where the court will schedule a hearing on that petition. If you do not have counsel at that point, you may be required to come back for that hearing, but there's no requirement that you live in North Carolina to have a charge expunged.
Perfect. And for those asking about the timetable, that same statute that I just put in the chat, it has information on about how long someone has to wait after their conviction slash sentencing to be able to potentially be eligible for an expunction. But those years are in that statute. Someone's asking if you can just, this might be something you've already stated.
That's
Um,
okay.
some general information about what to do if records have been expunged. Essentially, it was the person was found not guilty, but if that information is still showing up on like standard employment background checks, not stuff for prosecutors or law enforcement agency, but that stuff is still showing up on
So
employers' background checks.
So there's a little bit of confusion. Just being found not guilty or having a charge dismissed, unless that charge has occurred in the last few years since automatic expunction has happened, those charges will remain on your record until you actually execute an expunction petition. So just being found not guilty does not mean that the charge is not on your criminal record. It is still on your criminal record. It's just that it shows that you were found not guilty of the charge. And in order, unless that charge occurred after, I believe it is 2019, December in 2019, um, or was it 2021? I'm so sorry. Um, unless that occurred in the last couple, like last few years, the charge will remain on your record until you do the expunction petition. I'm not sure if that's what that person is asking, or if they're asking about the question that I answered earlier. If you have actually completed an expunction petition and that expunction petition has been granted, however, the record is still showing up, even though the court has granted your expunction petition that you filed, then you can contact a third party, like the whatever database that completed the background check, and ask them to remove that charge.
Right. And then if you could just state again about what agencies can still see expunged records and probably use those in their employment decisions.
Okay, so prosecutors can see expunged records for the purpose of sentencing if you were to get another conviction, and arresting agencies can still see them. As far as employment goes, it's very often, I can't give you a complete list, but it is very often the like if you were to apply for a job as a police officer, a corrections officer, a state job, something where you would have to be, qualified in a criminal defense position type of way. Those entities very often will be able to review your entire background check, including expunged charges, and use those for employment purposes. Again, I can't give you an exhaustive list. And there are also, certainly for like federal law enforcement jobs, I would think they would ask you the same thing. Also, occasionally you will have positions that will ask you specifically to to disclose your expunged charges. If that happens, you can bet that they are an entity that will be able to see that record.
How does someone get the filing fee waived?
So there is a form called the G106. It's called it's AOC CRG 106. It is called a petition to proceed as indigent. That form can be found on that AOC website that Marissa posted in the link a little while ago. And you would fill out that form. It asks some income questions, some questions about your circumstances. You submit that form with your expunction petition, and the court will decide on that petition to proceed as indigent and decide whether or not you can waive the filing fee.
Perfect.
And let me go back on to something I was saying earlier. Any charge that was fully dismissed after December 1st of 2021 should be automatically expunged 6 months after the charge was dismissed. Meaning if the charge was dismissed on December 22nd of 2021, it should be automatically expunged within 6 months of dismissal, or anything after that. So if a charge was dismissed today on the 6th of January on 2026, that charge should be automatically expunged from the system by July 6th of 2026. So you can always wait that out. If you wanted that to happen faster, you can still always submit an actual petition to the court system before that. If like any time after the dismissal occurred.
Um, if someone has multiple convictions in multiple states, is there a way to get all of those convictions in all of those states expunged at once?
I think the short answer to that is no, there is not. But I can only speak to North Carolina law. I am only licensed in North Carolina, and so therefore I cannot speak on law in any other state. However, I can tell you that every state has a different procedure surrounding expunction, if they even offer it. And so you would have to do every state's different procedure through that state separately. So as far as, even in doing everything in North Carolina, it's very difficult to get everything done at once, meaning like it takes a period of time, and you would have to use any other state's expunction procedures to deal with the charges in any other state.
Um, is the filing fee per charge or per petition?
per petition.
And can multiple charges be on one petition? Just to answer that
They
ahead of time.
can, as long as they were all disposed, as long as all the convictions occurred in the same county, in the same court, meaning either, let's say Wake County Superior Court, any charge that occurred, any conviction that occurred in Wake County Superior Court that is eligible for expunction can go on the same petition, or any dismissed charge that was dismissed in Wake County Superior Court can go on the same petition.
Gotcha. Um, for those asking about where to find that petition to proceed as an indigent form, I just put a link to that in the chat. Um, what's some supportive documentation that needs to be submitted with the petition? I'm a hope you understand what that means.
I do. So when you petition the court to expunge adult convictions, you must supply supporting documentation. That is what's called an affidavit. Basically, it's a sworn statement. You have to do one from yourself, swearing to certain things that are required by the statute and that are listed in that statute, 145.5, and then also one from each of two character witnesses. Attesting to the things that are listed in the statute. And those character witnesses cannot be related to you or to each other by blood or marriage. So, it has to be two completely separate character witnesses. I feel like people get confused about this. There is, like I said, a list of requirements of what you have to swear to in the statute. But it's basically the three affidavits that you have to submit, one from yourself and one from each of two character affidavits or character affiants, excuse me, not related to you or each other by blood or marriage. And those don't have to be, other than that, any kind of particular person. It doesn't have to be anybody of particular importance, as long as they meet the requirements of not being related to you by blood or marriage. And they do have to say how long they've known you. So, somebody who's just known you for long enough to be able to attest to your good character.
Gotcha. And I think the last question that I'm seeing at this point is someone is asking if something that was supposed to be automatically expunged wasn't, what can someone do?
If it wasn't, then you would need to submit if it's for a dismissal that was supposed to be automatically expunged, you can submit a petition to the court to have that charge expunged.
Perfection. Okay. Answer. I'm not seeing any other questions. Gonna give it just a second to see if anything else does come in.
No, that's fine.
Clarifying question
Okay.
is someone's clarified there is not a limit on how many offenses someone can request to be expunged, just the time limit to do so.
Um, it depends on, as long as they're the type of offenses that can be expunged, then yes. But when you get into felonies, you're only allowed to have a certain amount and you're only allowed to have them within a certain time period. So, there is a limit to how many felonies you can get expunged. And they must have all occurred within 24 months of each other. So there is a limit to that. As far as misdemeanors, as long as they are all qualified, as far as, what types of offenses they are, there is not a limit to how many there can be.
Perfect. And then if an expunction, my apologies, if an expunction petition is denied, is there an appeal process?
It depends on the reason for denial. That is something that you would definitely want to talk to an attorney about. I think that, Marissa, I think that question is a little bit too complicated
Perfection.
to go into in this forum.
Sounds good. Oh, someone's asking, I guess, if they're mailing in their petition paperwork, do they send, like, I guess, like the check for the fee
I would
with
do
everything that they're mailing?
if you are required to pay a fee, I would do a money order if you're mailing it. And you don't think you're going to qualify for the petition to proceed as indigent, I would do a money order made payable to the clerk of court, clerk of superior court in whatever county it is that you are filing in.
And then that 12/1/21 date for the automatic expunction, is that after the date of conviction or the date of dismissal, or is it like what's that
It
time
was, well, so
period?
those are only for dismissals, and the dismissal itself, so not the date of the offense, but the date the dismissal occurred would have to be after that December 1st of 2021. So whenever the
Perfect.
charge was dismissed, the date of disposition,
And that's 6 months after that
6 months
disposition.
after, that's correct.
Perfection. All right. Again, you can unmute in this form, so I will give a few seconds because I did see a hand just now to see if someone has another question. Okay. Um, I think this question is asking if there's for like that time frame to get any other adult that convictions expunged that you were mentioning earlier. If those convictions are in different counties, does the is the time frame the same?
Yes.
Okay.
So the time frame to, if you're submitting petitions in multiple counties to expunge adult convictions in several different counties, all of the petitions must be filed with the court within 120 days of each other.
Gotcha. Okay. As I am not seeing any other questions that we can respond to, and the thing, oh wait, hold on. I think this is a good question. If the charge, I guess, it started in district court, but the ultimate conviction was in superior court, does the petition need to be filed in both divisions or just in the division of the conviction?
That's a great question. Superior Court should get it unless it, if it was transferred from district court to superior court in any way, including an appeal, you should, wherever the actual final disposition of the case occurred, which would be in superior court, if both of those courts were involved, is where you need to file a petition. Not, you don't have to file one in district court as well. Now, sometimes there will be charges that are dismissed as part of a file in district court, and then some of the charges are then taken to superior court. In that case, you might have to file for the dismissals in district court, but usually it's just superior court.
Gotcha. Okay. Third time strong. As I am not seeing any other questions that we can respond to, I'm going to go ahead and address the situation about watching this program later. I'm going to go ahead and say thank you to all of you for joining us with a very, very special thank you to Trenner for presenting, for being here, and for answering all those questions. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available following this event. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other listen and learn programs, such as you heard about in the video, such as child custody, tenant rights, simple divorce, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their afternoon.